All right, we'll get started. I'm sure more people will come in, but we're about 3 minutes after, and there's a lot to be covered here. So, um, thank you all very much for being here. Just a quick update on Pismo Ventures and the symposium, the startup symposium. We had a lot of appeal this year. 182 companies signed up for this B2X or business to anything startup symposium. We had really a hard time selecting just 10 companies, so we ended up with 12 companies that will be presenting on Thursday. Um, so make sure that you join us on Thursday to meet the investors and hear the companies and hear the feedback, because we think that this really, as important as these webinars and the expert panels that we put together, it's part of the education that we try to provide to entrepreneurs, part of our, give back to the community and part of what we do to really help entrepreneurs with their journey. A little bit about Pismo Ventures. We are a venture firm and an advisory firm. We help startups with their startup needs, from their ideation all the way to raising capital and potentially exiting. We do also invest in companies, and we do help them raise capital as well. These events that we put together, the symposiums are really meant to help entrepreneurs with their journey, to really educate them. But also, we've been doing this for 4 years. The top 3 or 4 companies that have been selected to pitch and they rise up to the top have received multiple rounds of funding through our symposium and through the investor network that we have. So it is quite valuable, and we hope that you find the value that we bring together. So I will introduce Ken. Ken, he will take it from here. Maybe Ken, a little bit about yourself and what you do, about your firm, and then you can take it from there.
Okay, thank you very much, JJ. Well, hello, everybody. It's good to be here with you, and I certainly appreciate what JJ is doing with Pismo Ventures in really helping to just embrace the entire startup ecosystem and provide great education and great feedback to companies and entrepreneurs. So thank you for allowing me to be a part of it, JJ. A little bit about me. I have been in practice for over 30 years. My law firm, August Law Group, which is located in Irvine, California, specializes in business and financial transactions. We do a lot of work with startups in terms of advising on various aspects of the formation of companies, the capital table, all of the elements that go into running a company, and then ultimately the exit, whether it be by merger and acquisition or by public offering. So as a disclaimer, let me just say that what I am telling you today is intended to be informational only. Your watching this webinar does not create an attorney-client relationship with me. And so nothing should be considered legal advice to you specifically. This is more general information about things that you need to be aware of. If you have any questions and they don't get answered, my email address is here. Please feel free to email me, and I'll do my best to get back to you with an answer. So the title of this talk is Top Legal Mistakes That Can Kill a Startup. And you may ask, how can a mistake kill a startup? Well, there are any number of ways that an innocent mistake made by an entrepreneur can make it very difficult, if not impossible, to sustain a new company. Two categories of mistakes that I want to focus on today are mistakes that a company can make, which can cause it not to be investable, and also mistakes that can cause a company to fail to achieve its desired exit. So how do these mistakes occur? Usually they are unintentional, and they're caused by companies failing to receive the right advice before taking certain actions. It can be a failure to educate themselves. It can be a failure to identify and cultivate a team of people with experience in growing companies as management and board members or advisors. And sometimes it can be by taking shortcuts to avoid spending money on the right advice. So let's talk about what some of these mistakes look like. I've categorized them into different types of mistakes that hopefully will make it easy to understand what I'm talking about. Companies sometimes become trapped in several different ways in dealing with their equity. And so I want to talk about mistakes that specifically deal with a company's equity. That would be its stock, its LLC membership interests, its partnership interests, the equity that shows the ownership of the company. And there are a few things that we need to talk about. The first is mistakes that can occur because of a failure to understand the securities laws that are applicable to issuing the equity. And the fact that mistakes are made is not a judgment on the entrepreneurs or the company. It's very understandable because the regulations that I'm going to talk about are fairly complex and they're scary. But you need to know if you're going to be offering any kind of equity to employees, to directors, to investors, to friends and family, you need to know how the securities laws work. And so the first thing you need to know is that securities, and by that again, I mean your stock or your LLC membership interests and other evidences of ownership, are regulated by two different sets of laws. The federal law, which comes through the Securities and Exchange Commission, and state law, because each state has its own set of laws relating to the sale of securities in their state. And these laws are not uniform, and they can sometimes differ significantly. So startups must remember that every single equity, starting from the very first founder share all the way to massive investment, every single equity is a security, and it needs to be issued in compliance with the federal and state securities laws that apply to it. Securities also includes documents that are convertible into or exchangeable for equity, such as convertible notes, options, or warrants. Sometimes even straight debt instruments, like a simple promissory note, can be considered an equity if it's sold with an anticipation that the person buying the note from the company intends to make a profit, which is based on the success of the efforts of the startup. And that's sort of the classic definition of what is a security. A security is anything that a person buys for value, which can include time that they provide services, or cash or anything else of value, where they put that into the company with an expectation of making a profit based on the efforts of the startup and the people who work for it. So what does that mean? Well, every security that is issued by any company has to be either registered with the SEC for public sale at the time that it's issued, or it must fall within an exemption from registration, and the exemption has to apply both under the federal law and the state law. Now, in most cases, the initial equity issued by startups to founders, friends and family, or very early investors will not be deemed a public offering, which requires registration with the SEC. But to qualify for an applicable exemption, there are statements that the recipient of the security needs to confirm to the company in a written document where the securities are subscribed for. And filings need to be made with the SEC and with the state agencies that govern securities notifying them of the issuance of the stock. And this is called blue sky. So whenever you issue stock, even to your initial founders, to your friends and family, that stock must be registered or must fall into an exemption from registration. And in that exemption, there are filings, blue sky filings, that need to be made, both with the SEC and the state where the investor resides. The failure to comply with these requirements, which is applicable to the particular startup and its equity, can render that startup unable to give representations of warranties about its capitalization that are almost always required by investors or companies looking to acquire the company in the future. And it can lead to regulatory action if it's discovered, which can result in a cease and desist order being sent by a state or by the SEC, and could lead the SEC or the state regulators to require the startup to offer rescission to investors. Now, what do I mean by that? Well, rescission is the legal term for the remedy that investors are given in a failed offering of securities. And it requires that all investors are given the opportunity to return their equity to the startup for 100% of what they paid for it, plus a statutory interest rate that accrues from the date of the violation. Now, it doesn't mean that all investors will give the stock back if there's been some technical violation. If they still believe in the company, they'll want to maintain it. But if the company hasn't performed exactly as the investor expected at the time that they put their cash in to buy the securities, then this is a method that they can use to get that investment back plus statutory interest. And it's very, very harmful for the company, because most companies don't take an investment and then save it in reserve to pay it back. They use that cash. And so where does the cash come from in order to pay back the investors? And it can lead to insolvency and bankruptcy situations. The other thing is that violations of the securities laws, as well as any cease and desist orders that may come at a company, are all required disclosures for every private or public offering document that the startup provides to investors or delivers to the SEC for the rest of the history of the company. And so it's not something, even if it's remedied by rescission, you still carry that with you in your historical baggage for the remainder of the company. So it's very, very important to understand how these securities laws work, to become advised on what needs to be done to make sure that you're in compliance under both federal and state securities laws. Another mistake, which is similar, is using your equity as currency for services. Many startups, including many that I've worked with, fall into the trap of offering so-called sweat equity to individuals who provide services to the company. But when they do that, they don't realize that all compensation paid in the form of equity is usually treated by federal and state taxing authorities in the same manner as if the startup had simply paid cash for those services. Now, let me say, I'm not a tax expert and I don't hold myself out as one, but being on the periphery of transactions, I've seen this trap over and over again, and it's very difficult to get out of. Depending upon the relationship of the service provider, that person will either be classified as an employee or a true independent contractor. And therefore, they will receive either a W-2 or a 1099 form that will be required to be issued to them, reflecting their wage compensation paid to them during the year. The payment of wage compensation to employees triggers taxes not only for the employee, but also for the employer. So if the startup uses its equity to pay for employee services, and it hasn't reserved properly for the payment of employment taxes, and it doesn't file the right tax forms with respect to those employees, it can create major liabilities for the startup, which must again be disclosed to all investors. The value of the equity paid will be either its fair market value on the date that the equity was received or granted, or if it's not ascertainable at the time, as is the case with many startups, then the market value of the services that have been rendered for that equity will set the value per share or per unit of equity paid. So if someone does a job for you that would normally be $30,000 and you pay them in stock, but that stock doesn't have a market value because you're a startup, you have no trading and really no basis for what the value of the stock is, then you take that $30,000 and divide it by the number of shares of stock or units of LLC membership interest that you've given to that person, and that becomes your de facto per share value. And that's what needs to be recorded for tax purposes and what needs to be looked at to see what employment tax or other liabilities you may have as a result of using your currency, your equity rather, as currency for those people. And it's also important to make sure that you understand whether the person that's receiving that equity is in fact an employee or a true contractor. There have been many changes in the laws recently as to how to classify them. Generally speaking, if the role is a necessary function for the company to conduct its planned business, such as pilots for an airline or drivers for a company that's a gig, a driving pickup company, then they are required to treat those people as W-2 employees and not as contractors. And even if you sign an agreement that claims that they're an independent contractor, that often is not the case, and liabilities can come up there as well. So make sure you understand how to classify your employees and contractors, whether you pay them in cash or in equity. Another trap that I often see clients come in with is that when they became a startup and they took in their very earliest investors, maybe friends and family, maybe not, they promised those people to maintain their percentage of ownership. And one principle of corporate functioning is that every time new equity is issued to anybody, it reduces the percentages of ownership of the existing equity owners by a proportionate amount. So in other words, if you have given out equity, you look at how much equity is outstanding at the time, and you issue new equity, 20% new equity, let's say, then all of the existing equity owners, just by mathematical consequence, have their ownership percentages reduced by that same 20% that you just gave out. And so dilution is an important thing that you need to keep your eyes on as you're issuing equity. But sometimes, in the zeal to make early shareholders happy, a startup will promise a shareholder that they have the right to maintain their existing percentage without subsequent dilution with new issuances, notwithstanding that, and without paying for it. And the problem with this type of anti-dilution is twofold. First, it creates disproportionate dilution for the other equity owners of the company now and into the future, because that dilution has to occur somewhere mathematically. And if everybody is not receiving that dilution on a pro rata basis, then somebody's receiving more dilution than they would have been and should be. Secondly, if someone receives equity without paying fair value for it, then the amount of equity that they received, which still has value to the corporation, is subject to attack by creditors and others, because it represents value that should have been received by the company in consideration for the equity issued. Also, at some point, if the company is ever audited, say for SEC purposes or in an acquisition, then there will have to be some allocation made to cover that missing value, which can have a disastrous effect on the stated earnings of the company. Not to mention that if it's failed to disclose that risk, then it opens the company up for claims of security fraud. Like we discussed earlier, you make those representations and warranties about your company to an investor, and if it turns out not to be true, if those disclosures aren't complete and correct and comprehensive, then that investor can come back and claim securities fraud. Again, rescission being the principal remedy for that, which can be disastrous for a startup or any company for that matter. Now, I know that there have been webinars this morning on intellectual property rights. I just want to talk about a couple of the mistakes that I've seen in my practice, which involve intellectual property rights. The first is the failure to protect trade secrets and other proprietary material. For most technology startups, their proprietary intellectual property is their most valuable asset. Yet many companies do not take the steps they need to protect this asset to their peril. And so to avoid this, startups should definitely work with an IP counsel to determine what proprietary rights can be protected, either by filing of patent or trademark or copyright, or under other federal applications for protection. They should develop and adopt a guideline for the protection of trade secrets, that is, intellectual property that doesn't get filed with the Patent and Trademark Office, but still has proprietary value. And you have to maintain the trade secrets policies that should be adopted by the board of directors of your company or the management board of your company. You have to maintain that in order to continue to protect those trade secrets from becoming public information and no longer proprietary and valuable to you. So it's very important that anyone who is involved in developing or creating or modifying or enhancing your company's IP, whether it's involved in the R&D of your technology, or maybe they're developing graphics for your company, whatever that IP is, if you have outsourced that to anybody, they must have either a written employment agreement if they're a W-2 employee and going to be performing work on the IP, or if they're an independent contractor, then they must have a contractor agreement which confirms that they're being paid to touch that IP, they're being paid for it, and that the payment is their only compensation, and that any and all IP that's developed or created by them is what's known legally as a work for hire, and that they disclaim any rights or interests that they may have in them, and that they'll sign any transfer or assignment document that you might put in front of them in order to affirm that they have no personal interest in the IP that they helped to develop. I have seen multiple deals, multiple investment deals killed, just aborted right on the spot, because companies were not able to provide to the investor in their due diligence documents showing that people who work in the company or who worked as contractors and touched their IP did not sign these work for hire agreements, or signed ones that were incomplete or somehow inappropriate. So it's very, very important to make sure that for each person, you have a file, just like your employment file, that has their IP disclaimers in that file. Similarly, if you provide any product that you have to a third party for testing or evaluation, it's very common, unfortunately, that there is not an appropriate evaluation agreement put in place that clarifies exactly who has the rights to the results of that testing, who will have access to them, how those results will be used, and that the party conducting such testing or evaluation does not have the right unilaterally to publicly disclose the results without first obtaining your written consent. These things are very, very important for maintaining the value of your IP. And it doesn't come through the IP, it comes through your contract relationships with these outside vendors. And so you really have to make sure that the language that's necessary to protect you is in all of them. I had a client yesterday send me an app development agreement, and it didn't have anything in it about the IP ownership of that app when this developer was finished producing it. And this, if they don't change that agreement and specifically put that language in there, it will tie this client's hands. It could kill the company very easily. And as I said, investors and potential acquirers will require you to produce written agreements with all of these people containing these protections that the company is engaged. And it's very, very important to do that. Now, I mentioned earlier about the disclosures that have to be made to investors. Let's talk about some mistakes that occur in that context. The very first one that I see is companies who come in and they've issued stock or other securities, but they failed to provide any kind of written offering document. All offers and sales of securities should be made through a signed subscription agreement, which contains both representations and warranties of the company about itself, as well as investor representations as to the qualifications of the investor to be able to invest in the company. And these will support the basis of the exemption from registration that the company is relying on to sell its securities to that investor in a private placement. These documents, ideally, they should be accompanied by a disclosure document, such as a private placement memorandum, that clearly sets the disclosures that the company is making about itself and its technology to investors. If all of the investors qualify as accredited investors, which would be confirmed in the subscription agreement that I mentioned, that they're accredited according to SEC standards, then even though it's not legally required because the SEC presumes accredited investors to be able to protect themselves better than non-accredited investors, it is still a best practice to protect the startup against claims of securities fraud to deliver a PPM. If any investor in the offering is not an accredited investor, then it is absolutely necessary by law to provide these disclosures. And the reason that I say that it's a best practice to provide one, regardless of whether your investors qualify as accredited or not, is that the PPM, this private placement memorandum, is an insurance for the startup so that there is a written document that clearly states the claims and the information about the company that are being made to the investor to induce them to make an investment in the company. If there is no such document, then after the sale, anybody can allege that you said XYZ about your company or its products, and there's nothing to prove that you didn't say it. So I like to have clients refer to a specific document published as of a specific date in the subscription agreement, that the information provided is clearly identified, and then allowing the startup to make clear that unless the information is contained in the specific PPM that was provided, then nobody should rely on anything else as being either accurate or complete.
So, Ken, we have a quick question here.
Sure.
And before that, your camera may be too close to you, and your face is not fully visible. So maybe that could help.
That better?
Yeah, way better.
Good.
One of the question is, would you be able to share the material you're reading, maybe if you have them in a document or in a PowerPoint, maybe after?
Yes. if anybody would send me their email address or connect with me on LinkedIn, I'm happy to share these notes.
Okay. The other question is, can apps be patented or copywritten?
That's a great question for somebody like Quan Nguyen, who's
Right.
an
That's
IP expert. There are protections that apps can have, but I'm not the guy to really delve into that.
yeah, I figured that, but I figured since you touched on it and the
Nope,
question is
it's
there.
a fair question.
Okay. All right. Thanks. That's it.
Thank you. So just talking a little bit further about PPMs or investor disclosure documents, the thing that entrepreneurs and startups need to understand is that if a PPM is provided, then every statement that's made in it is relied upon by the investor to be completely true and not misleading and to be comprehensive. If anything is untrue or is misleading, or if there's any material information that should have been disclosed but was omitted, then this can lead to claims of misrepresentation and securities fraud by anyone that is invested in the offering. So therefore, companies have to make sure that their due diligence materials support their representations. For example, if you state that you have a license that grants rights to some particular technology, then you have to make sure that you actually have that license written, fully executed, and dated. Because if you don't, then you actually don't have a license. And the fact that you have indicated that you do, even though in your mind, when you said it, you believed in good faith that you did have one or would have one, or somebody told you you had one. But if that written document is not there, signed and dated, you don't have one. And so what I like to do is to have clients keep a file folder containing all of the backup information that supports each representation made in a securities offering document. And these can either be paper files, or it can be in files on a shared storage site that can also allow investors and others easy access to the relevant due diligence items. And the way we do it is we have file folders that have numbers assigned to them, and we provide a due diligence questionnaire that lines up so that every folder and every piece of due diligence that is obtained are completely numerically aligned, and it makes it much easier for people to follow. Now let's talk about mistakes that involve your capitalization table. Startup entrepreneurs have to work with professionals to help them anticipate the cap table that they will need to get them all the way through profitability. And this involves understanding how much money you will need and in what stages or time periods you will need it. So companies have to back end into their full cap table so that they know how much equity they need to issue to founders, to early investors, and others in order to manage the growth of the company and the dilution to shareholders. Because once that startup has begun to appreciate in value, it can become very difficult or prohibitively expensive to go back and to issue additional equity to founders and others to make up any deficiencies that were not planned for. If your board of directors at that point will even allow you to do that, and sometimes they won't. So a lot of founders can lose significant value by not determining upfront how much equity they want to reserve for themselves, so that when they give out all the equity they're going to need to get to profitability, that percentage is remained undiluted. You also have to remember to reserve equity for any activities that you anticipate occurring in the future, such as an equity plan for officers, directors, or employees, or stock or equity for acquisitions, or joint ventures or other strategic transactions, which are known potential dilutive activities of the company. And if you know that you're planning on doing that, not only do you have to reserve for it, but you also need to disclose that in your securities offering documents so that investors, when they buy in to a particular percentage, understand that your intention is that that percentage will be reduced by hopefully a value transaction that makes up for that dilution. But if it's not adequately disclosed, again, people can claim it was a material misrepresentation, and that can lead to problems with your investors. Another issue always is valuation. The question of what value your equity has when you sell it. It's always one of the most difficult questions that a startup faces, and particularly if a business is innovative, if it's new and it's untested over a long period of time, and there really is no competitive base to look against because you're so innovative that nobody's doing what you do. So in that event, companies really need to work with advisors who have experience with growing startup companies and can help them navigate those negotiations over valuation. But extreme caution should be taken to ensure that valuation is not pushed so high in any given sale that it can cause later down rounds of investment or loss of potential future investors. So again, it's back-ending into where you think your cap table needs to be by the time you get to the end goal, and managing not only the number and the percentages of shareholders, but also where your value is. Strategies such as negotiated clawbacks, milestone rewards, deferred valuation agreements, such as a SAFE, or other similar arrangements can be useful tools to bridge the gap between the extremes in valuation as to what the company believes its company is worth and what the investors believe it's worth. Now let's talk about some mistakes that involve non-securities related regulations. It is important to work with professional advisors to familiarize yourself with all the regulations that have relevance to the business that you're conducting. Because when a startup gets into business, it's in a particular industry segment, and that segment has rules and regulations that will apply specifically to that industry. So for example, if your business has a website, and let's say you're an e-commerce business, so you're collecting information on that website, are you in compliance in every jurisdiction where people can access that website? Because most jurisdictions have privacy and other requirements which must be complied with. In California, we have what's known as CalAPA, or the California Online Privacy Protection Act, which applies to every single company anywhere whose website collects personally identifiable information from consumers in California. Similarly, if your website can be accessed and used by anyone in Europe, then it also is subject to compliance with what's called the GDPR, the General Data Protection Regulation. And that regulation is among the strictest in the world and can result in millions of dollars of fines if it is not complied with. Regulators have also been cracking down recently on websites that do not comply with the accessibility requirements of the American Disabilities Act. So it is recommended to have your website reviewed for compliance with these requirements, because penalties for non-compliance can also be very severe. Similarly, if you're engaged in making sales of products or services internationally, then there are a whole host of regulations that apply to you. Companies engaging in import and export, for example, must consider having a guideline of policies adopted by your board dealing with ensuring compliance with the Foreign Corrupt Practices Act, known as the FCPA, as well as anti-money laundering regulations, or AML. These guidelines should dictate what the company's position is on the need for compliance with these laws, as well as the system of checks to make sure the company recognizes and takes appropriate actions with respect to potential violations of these laws. If your business involves the marketing or sale of products or services that are related to defense or homeland security, then looking at the laws which regulate the export and sale of these items, or the need to obtain governmental licenses under the framework of the International Traffic in Arms Regulations, ITAR, or the Export Administration Regulations, EAR, is very, very important. And again, if your business involves commercial activities with international customers, looking at the way in which you're ensuring that your company is not violating US sanctions, which prohibit such activities with certain countries. Currently, for example, no US company can engage in commercial relationships with Cuba, Iran, North Korea, or Syria, as well as particular individuals or entities who have been specifically designated for an inability to have commerce. And that designation comes from the US Office of Assets Control, known as OFAC, and it is illegal for any US company to engage in financial transactions with any either sanctioned companies or designated individuals. So you have to know how to find out if you're doing business in those areas, if you're selling to distributors of your product who may be doing things, you want to make sure that your distribution agreement has very tight language that regulates what they can do, who they can sell to, and how they will not violate the laws that you are subject to. Another highly regulated industry is the health and wellness industry. And if you're collecting or you're otherwise exposed in any way to information regarding the medical conditions of patients, then you have to look at all the federal and state laws protecting medical health records, such as the Health Insurance Portability and Accountability Act, known as HIPAA, which provides very stringent financial penalties to anyone who violates its requirements. And these things need to be in written documents with anybody that is involved in working with you, either on your website or if you're collecting this information from them. There are numerous checks and balances that we have to go through. Now, because of the problems that can occur if any of these regulations are violated, companies now, using best practices, are having their boards develop and adopt a policy for whistleblowers. And that policy needs to go into your employee handbook or otherwise be communicated to all employees to let them know if they perceive that there's an issue, what steps they should go through to report that issue to management so management can appropriately address it. And they also need to know that they're protected if they come forth, and that the company cannot, under law, fire them or otherwise create some retribution while they're working there as a result of them stepping up and reporting potential violations. This is helpful to the company too, because it will tend to bring things up early enough that they can be adequately and appropriately addressed before they become the kinds of things that can put you out of business altogether, because the federal government or the state government has come in and now they're finding these problems. So the point of all of this is that entrepreneurs need to consult with professionals in their industry segment to clearly understand all of the rules and regulations which apply to them and develop a method of ensuring how they will in fact comply with these laws and what the steps will be if they don't. Another thing that I like to see clients do startups especially, is to develop procedures for what happens if there is some sort of a disaster, in the sense of a press announcement, or something has come up which is highly negative to the company. And how do you address that? Do you have PR people that are in step, that can jump right in and take care of the problem? That's another thing that I've seen startups really get hurt with, by just not having that additional planning, and it's highly recommended. So that's basically what I've got for entrepreneurs. JJ, are there any other questions?
There are a couple questions. One is, what measures are in place to limit the startup's liability? Is there adequate insurance coverage for potential risks?
Well, there are certain insurances that that can be purchased. They're often highly expensive and onerous for really startup companies. Certainly, directors and officers insurance is something that many directors and officers will require if you're asking them to step in to one of these roles, because of the fiduciary duties that they have. So that's a possibility. I've seen representations and warranties insurance in the context of acquisitions. I haven't seen it in the context of securities offerings, but that may be a possibility. But really, the best insurance for companies is to make sure that they have surrounded themselves with a team of competent advisors that have been through the process multiple times and can just help to mitigate the risk, so that companies can breathe easier when they go out and undertake these activities. And just understanding the seriousness of the issue is a good first step.
All right. There's another question. Any other questions, please post them in the Q&A section, please. Another question here is, for startups in pre-seed stage, when they call for co-founding teams, need to build the startup, what kind of pre-legal agreements to have if the startup is not registered yet officially?
Well, that's an excellent idea, and or question rather. And one of the legal issues that is pertinent to that discussion is that if you have a group of people who are engaged in a common business, and you haven't incorporated or formed an LLC so that you're operating within that, then by law, you're a general partnership. And the law says that every general partner is jointly and severally liable for every other general partner in a partnership. And so that means that if somebody is driving home from work one day and they hit a kid on a bicycle, and that liability is litigated, then all the other general partners have liability for that, because they're in a general partnership. So the first piece of advice is, form your organization as early as possible in order to insulate and protect against those kinds of liabilities. But there definitely should be agreements in writing among the principals that are going to form an organization. For a corporation, it's sometimes called a pre-incorporation agreement. You can have pre-agreements for the formation of an LLC as well. And that should clearly define not only what everybody's rights and interests are, but also how liabilities will be dealt with, and receiving indemnification, for example, from people that may create certain liabilities because of the function of the work that they're doing.
All right, Kent. Yeah, thanks. So if you are looking for a copy of Kent's presentation or talk today, please email him. His email is right on next to his name, and then he will send it out to you. There's another question. Can you create a private agreement with friends and family that states your friends and family will get some percentage that you earn on buyout? They would not get any equity in the company itself. They would not be basically on the cap table, but they'll receive something?
So again, excellent question, and thank you for bringing that up. That is a mistake that I should have covered. I must have skipped over it because it's so important. In order to receive anything of value for bringing investors in, for having people buy your securities, you must be registered as a broker, as a securities broker. You must be licensed with the SEC or with FINRA, which is the regulatory body for brokers and dealers in the United States. Because the exemption that you're relying on in the private placement says that nobody has received any commission for effecting a sale of securities. And once that's done, and you've given somebody a promise, even if you haven't received it yet, but it's just a promise to do that, you've spoiled the entire offering. You've defiled it, and you're going to have to give rescission back to everybody that invested in the offering, because that is a problem, and it will come up. It will come up in an SEC review if you're intending to go public. It will come up in an acquisition due diligence. Yep, a private investor transaction, and sometimes, it's funny how these things happen. We had a company that was slapped by a state regulator because one of the brothers of the regulator was so excited by a startup company that he sent it over to him to invest in. And when they did the due diligence, they found out that this sort of giving commissions to an unlicensed person had happened, and the company ended up getting sued by the government because of doing that. So you never should award anybody cash or securities or a promise of anything of value, a trip, nothing, for bringing investors to you. Now, having said that, there are some states that do provide specifically for a finder to be able to receive something for being a pure finder. But the definition of a pure finder is very different in those situations, and it has to be looked at and followed carefully. That finder cannot participate in any of the meetings. They can't advocate the investment. They can't deliver a business plan, nothing. They cannot be related in any way. They can simply provide a name and then step into the background. And only in certain jurisdictions is that allowable.
Very interesting. Any other questions? If you do, it's the last chance for you to ask right now. All right. Well, Ken, that was really good. So yeah, if you do have these in some kind of a documentation, PowerPoint or whatever, that would be great to share with the audience. Appreciate the insight very much. This was very, very valuable. Like I always say, every time I listen to a webinar, or I learn something. So this is absolutely fantastic. Thanks very much, Ken. Much appreciated.
Thank you very much. And yes, happy to share with anybody that wants to connect.
All right, everyone that's on, please make sure that you connect tomorrow, or I'm sorry, Thursday. Thursday is the pitch day where you can see the companies that made it to the final day, and also meet the investors and their feedback as well. Thanks again very much. Have a great day.
Thank you.